All right, guys, thanks for showing up. We have a lot of food here, Mexican food. For those on Zoom, you're missing out. I wanna thank Alba Moy from Moy Escrow for the food. We even have dessert here, so pan dulce. And I also want to thank Yolanda with WFG. I want to remind everybody that we will be recording this, and I'll be sending it out probably tomorrow when Edgar gets back. Without further ado, I'll hand it over to Alba Moy and Yolanda.
Thank you, Ruben. Thank you everybody for here, allowing us to join you for this lunch and learn. My name is Alba Moy. I am from Moy Escrow. I'm just 2 blocks away from here, and always ready for you at any time. I have been doing escrow from 1979, so this is my 44th year doing escrow, and we just celebrated Moy Escrow 33rd anniversary.
Happy anniversary!
Thank you. So we're very blessed. I am truly blessed in doing something I really enjoy. I love escrow. My life is escrow. I have no other life than escrow. Luckily, I'm the husband. But it's just so rewarding to be able to help. I love people. So that's, since I was a little girl, I always like to serve. So serving is my middle name. Yeah. And the escrows are my children. So when I handle an escrow, I treat them like if they're my kids. And when they go out and they close escrow. So to open escrow is so exciting. You must have a fully executed purchase contract. That's important. Okay. All the initials, all the signatures. Sometimes the sellers forget to sign because they're so involved initially in DocuSign that they forget to sign. But do make sure they do sign the purchase contract and all the counter offers. So to open escrow, I'll need a fully executed purchase contract and counter offer. And when you are the buyer's agent and you're handling the buyers, please make sure their name is correct on the purchase contract. You might know them as Bobby or Rob or something like that, but their true name might be Roberto or Robert. It could be, you won't know them by Mike, it could be Michael. In other words, it's okay to ask for a copy of the driver's license. So to copy it from there, at least you'll know they have a valid ID for later on for notarization and And if the sellers are on title, make sure that they're both or whoever's on title, they're alive. So if they're not alive, please let the escrow officer know so that way they don't include the name in the escrow instruction, because sometimes it's very sensitive, especially when they recently lose their spouse. We deal with very sensitive sellers, and they get really emotional, especially when they sell the property. Even if their husband and wife still get emotional, and so that's important. I'm doing the SI at the beginning. The confidential information statement is good. It's very important because we need to clear the name of the sellers, even the buyers, because a lot of the lenders like Rocket Mortgage, they require the buyer's name to be clear. So if they have any liens and judgments against them, the lender wants to know. So that way, so it's all of these little tips it helps with closing the escrow smoothly. Because the less delay, the sooner we close, the sooner we get paid. That's the most important, the most exciting part. We get paid, the buyers get their house, they get the key, the sellers get their money. Yeah. So.
And that part, let me just jump in a little bit on the title part and the beginning of a transaction, or even let's even backtrack a little bit. But before I get into it, I think most of you know me, Yolanda Martinez Arenas, WFG National Title Company. I've been in the business 41 years. So Alba and I, between the two of us, 85 years. So a lot of knowledge and a lot of experience, and that is valid. And I emphasize that because I see all the problem files, unfortunately, and I know Alba sees a lot of problem files. And so when Alba asked me, I joined her today in this office presentation, talking about red flags and escrow and how to have a successful escrow and close. I was so excited because I'm very passionate about this, because almost on a daily basis, I hear all the problems. I get calls from agents and realtors all the time. And I even get calls from the buyers and sellers because the agents give them my name and phone number, which I'm completely fine. So, and it's important. Before I even got into title, I did sell real estate for 4 years, from 82 to 86. So I've been on the other side of the desk. I understand what you're going through and I appreciate every step of the journey that you go through, and it's not. And so that's what helps me to understand what is going on. But when it comes to opening up escrow, and I love the point that you made, Alba, regarding make sure who's on title. We get this all the time. Open up escrow, mom died, dad died, and you're working with the son or daughter. Now, you know that as the agent because you've already been in contact with the heir, with the son, with the daughter, with the successor trustee. But you have to remember, escrow doesn't know that, and nor does title. So it's so important that you ask and research if the property is in a trust, and I know Abel's going to touch on this. If the property is in a trust, you will have to ask for a copy of the trust and forward that complete trust to escrow. And then in turn, escrow forwards it to us. Now, it's not that the title company wants to be nosy and want to know their business. No, we need to know who is the successor trustee, whether it's one or two, the powers that were given, the beneficiaries. That's what we need to know. Is the real estate mentioned in there, specifically the one that is the subject property being sold? We have to know that, okay? Because we have to abide by the wishes. Okay, and that's what we're doing. We're just going by the wishes. So it is important that we get that. If the mother or father or loved one just passed away and they have not recorded the affidavit death of a trustee, we will need a certified death certificate. And it's not us, it's the Hall of Records, because that document needs to be recorded and they do not accept copies, okay, because they feel it could be altered and all that. Everything, it has to be an original or certified. Do you want to add on that on the recording?
Right, for
Yeah.
recording purposes. And also if there's any amendments to the trust, because sometimes there's amendments to the trust, so the successor trustee that you're dealing with might not be the real trustee with the authority to handle the transaction. So you need to have, if there's any amendments, you need to, because a lot of times there are siblings, family involved, and there's people are so crazy. So if you're dealing, you throw the transaction, and then somebody comes out and say that, oh, I'm supposed to be the one authorized sign, and then we were not aware of it. So then that's where the title company, you all get into issues that we shouldn't be getting.
So that's why it's when you're taking a listing, even from the beginning, and I not just speak, I just don't speak for WFG National Title Company, but I think I speak for all title companies. Who, as a listing agent, can order the prelim up front, and it's very important and crucial, especially if the property is vested in a trust, or if you're working with a seller who's owned it for a very long time. And this is why, actually, Anna and I, we have one right now. You know, it's I think a 7 or 10 day all cash transaction, but the property has been owned by this family for, I want to say, either the 60s or 70s. They've owned it for a long time, and all title companies, we have to go back to the last insured transaction. So our search is not just 1 year or 2 years. We have to go back to the last insured transaction. And in this particular case, I think it was in the 70s or something. I've had some no title insurance since the 60s or 50s. Now here's the situation with that. Those prelims take longer. Nothing that the title company can do. And we feel bad when it's a fast escrow and all cash transaction and we can't get that prelim out to you right away. But what we call, and you're going to hear this terminology sometimes with your title rep or with escrow, we're waiting for a starter. Or we have to order the documents from the plant. That's when the documents are really old and we don't have access to them on the premises. Now, title companies have a lot of documents and the film, but we probably only have like 80, maybe or late 70s. Anything older than that, you're gonna hear, we have to order from the plant. We're waiting for a starter. That's a neutral site that is an archive that holds all the documents. And so that's why if you are getting a listing and it's with a senior citizen that has been on title for a long time, and there's been no action as far as refinance or any type of title insurance currently, it is so important that you order that up front. Okay, because it's gonna take a little while, and it's, you know, and it's not that your title company's dropping the ball or doesn't want to do it, it takes longer to search. Yes, Oscar.
Yes, so when you say that they have to go through that information set from the county, record or something?
It's a plant that holds all the microfiche, like for LA County, all the recorded old documents on file, old. Like documents that were recorded in the 50s and 60s and stuff like that.
They do have it, they have to.
They have it, but we don't have it. The title company, like, it would be too expensive and almost impossible for each title company to afford that microfiche and that information to have it on their premise. We have information, probably only dating back to the 70s, you know. So anything older than that, a lot of the title companies, and this is for all title companies, we have to get it from the plant.
And when you say that's gonna take longer than what we're talking about,
It could be a week instead of, you know, I know we're, you know, usually prelims of residential, you know, sometimes 24, 48 hours. It usually, I think it took about a week for ours. It took a week. And now if it's a busy time where the sales are exploding, Oscar, it's gonna take 10 days. Okay, yes,
So this is, yeah.
Go ahead.
I just want to be sure. So this is upfront, premium upfront.
yes, and
Only
there's
for-
no cancellation.
Only for seniors.
No, actually, I suggest, and it's a very good practice, that as a listing agent, that you order the preliminary report once you get the listing. And title companies allow that, and there is no cancellation if your sellers change their mind, or they sell it, but it falls out of escrow, and then they decide not to sell, or there's a you know, a change in events, you know, somebody gets sick or somebody passes and they don't want to sell, there's no cancellation. But here's the nice thing about having that prelim up front, and I know Alba's gonna jump in right now. This is why it's important. When you order that prelim, review it right away. I encourage everyone. I know everybody has a wonderful escrow officer to look at the prelim, but it's humanly impossible for all escrow officers to review every single prelim as it comes in, especially in a refi booth. Now, right now, things are kind of calm. They probably do it now, but I'm saying, you know your client best. You're the one that is in first communication. You already know the story and the history. So if you have a listing coming up and you get a listing and you already know that mom and dad are on title, but the mother passed away, and that they had an old deed of trust, a private Benny, a carryback from the previous owner, and it's paid off. So you know all that. You know that the property should be free and clear. We order the prelim, you get it. Mom and dad both show on title because they have not recorded the affidavit death of a joint tenant. And that private Benny, and I believe you, it's paid off, it's still showing on the chain of title. So now, what is nice is that you could start cleaning stuff up ahead of time. You know, you could start fixing things, we can start working on the file even before you go into escrow. Like for an example, the private Benny and your client, private Benny is a private individual who plays as the lender instead of a mortgage company or a savings and loan. So if I buy Alba's house and she loans me $10,000 as part of my down payment, I'm gonna have a $10,000 note. It's with a private Benny, a private citizen, not a bank. So then 5 years later, I pay Alba off that 10% deed of trust, but we didn't record a full reconveyance. So now it looks like in the eyes of the public, because there's no full reconveyance, it looks like it's still outstanding. Now you have to remember, and I always have respect for your customers, and I always try to see through their eyes and understand. Now your client may know it's paid off, But if it's still on the chain of title, in the eyes of the public, it's still outstanding. So that way you need the proof, right? That's why you need the proof. So it just gives you time to work on that. And in a case like that,
You have to order a loss instrument bond if you cannot find the beneficiary that they have passed on. So we gotta work, it's for cleaning up. Also, I wanted to mention that
That's
a
what.
lot of,
What's the name again?
the
Loss
loss instrument bond, it's like a bail bond for a deed of trust instead of a person.
Law instrument.
Loss.
lost note and, yeah, or lost note and bond.
Yeah.
Mhm.
Can
And
be expensive. Oh, the
Yes.
first time I heard that.
it's called a lost,
Every time I complain.
lost note and bond. And everybody asks for pricing. It all depends on a couple of factors. One, how old is that deed of trust? How big is that deed of trust? And does your client, does your seller or the beneficiaries, do they have any proof? A letter, a bank statement. Back in the day, there used to be bank, like, kind of like bank statements, or if you have anything, that helps. The more proof you give to the lost note and bond, the better it is. Go ahead.
How can we file a reconveyance deed? Who's gonna do that for us?
Okay, when you order the lost note, the bonding company will issue the bond. And then we'll prepare the documentation it can be signed by the seller.
Usually, we have the homeowner, property owner go to escrow or go to title rep.
No, we have to have an escrow for us to request a bond. And the seller will be the one to sign, because the seller is
What
insuring.
about if they're not selling? They just file a reconveyance deed.
If they're not selling, then they need to we'll require them to call the bonding company. So they can get the application and do all that paperwork with the bonding.
Right, but if it's what we discover on a sales transaction and it comes up on the preliminary report, that there's an old deed of trust for maybe 10,000 back in 1988, and it's been paid off. We do as a title company help assist in trying to find the beneficiaries. Like, we'll run their name, we'll run the address to see if they're still living at that site. So that way we pass the information on to escrow to try to contact them to see if the family's still alive, or sometimes the children, and then we could do a substitution of trustee and
With the
full
beneficiaries.
beneficiaries, if we can locate the beneficiaries. Yes.
Most of the lenders, they don't bother to file reconveyance deed.
I like,
Most of the lenders.
you're right, and we come across that a lot, and where we come across that, especially, how many years ago, when you started seeing a lot of lenders merge, buy out one or the other, that's when it starts getting a little crazy. So if you get a listing and there's an old deed of trust, and it might be with some bank that's no longer in existence, I'm gonna say Countrywide, I'm gonna say First Interstate, I'm gonna say Great Western, I'm really aging myself.
New Century.
Yeah, New Century, so one, or even mortgage company, that's okay. Call us, because we have a system that can tell you this mortgage company was bought out by this mortgage company, or this savings and loan was bought out by this savings and loan. So now, for an example, like Countrywide is a very good example, Cindy, got bought out by Bank of America. So then you would contact Bank of America and get a substitution of trustee and full reconveyance. So there's a little late work there, there's a little bit of work to do, but you see how important, if you order that preliminary report upfront, you can clean up a lot of this, and then you can see who's exactly on title, who do we need to get affidavits of death, and of course, all of that, even a lost note and bond, and even recording, all that's done with escrow and title. And we record it all during the time of the transaction, correct? So don't feel like your client has to separately, outside of escrow, have to do this or that. No, all this can be done through escrow and title and
And
at the
getting
closing.
paid through the proceeds on the transaction.
Mhm, yes,
Yeah, I might have a with trust,
uh-huh,
great trust. The wife, the spouse died 3 years ago, and now the remaining husband died this year. Do I still need to go back and get the certificate of death
yes.
on the wife?
That is a very good question. So I'm gonna repeat it so that my Zoom family
Yeah.
can hear this question, because this is very good. So the scenario is working on a listing. One of the owners, I think the wife you said, or one of them passed away 3 years ago. And then just recently, I think the husband just passed away. So now both owners are deceased. Hopefully it's in a trust, or else it's gonna have to go probate. But here's the thing, and I'm glad you brought this scenario up. So now, let's just say it's in a trust. I'm just gonna say for easy purposes, the mother passed away 3 years ago. The father just passed away a couple of weeks ago, and the children are the heirs and the beneficiaries, and they're gonna sell. Let's just say that for purposes. Well, this is what's so important, and this is very, very important. If it doesn't take anything away, take this thought away. Because the family and the husband did not record the affidavit death of a affidavit death of a trustee 3 years ago. It's gonna have to be done during the time of the sales transaction, along with the father's affidavit. And the reason why every deed has to be recorded, it's because think of this as a chain of title. It's like a chain, no missing links. Because let's just say John and Ann Smith were on title. Why isn't John and Ann Smith signing the grant deed to the new buyer, to Peter? Because John and Ann Smith are deceased. So we have to fill in the missing links. We have to record the deeds in sequence, in the right order, to now transfer the property over and deliver clear title to the new third-party buyer. Does that make sense? So that's why we can't leave off Ann's death certificate, and we can't leave off the father, John's death certificate. We have to record everything, because why isn't John and Ann signing? Because they are deceased. You know that, the family knows that, but the public and the chain of title doesn't know that. So we have to fill in all the links. We have to record every single deed in sequence. Everything has to go smooth, because as a title company, we have to deliver clear title to the new owner, and it's very important and very valuable. But here's the more critical thing, and I want everybody to know this, because I got a call yesterday and today, and I almost get this on a daily basis. Feel free to jump in. Sorry, I talk a lot because I have a lot of files. Sorry, I'm so passionate about this because I want you guys to know this, and I don't want this to happen to you, especially because you're working with seniors. Whenever you're working with seniors, especially in like a trust situation. Okay, so let's just say that the heirs, the children, one of them is a successor trustee. Okay, so that is all done. The deeds, the affidavits are all done in escrow at the time. And then the son is a successor trustee, and now he's going to sign the affidavits of death. And then he's also going to sign the new deed to the new buyer, to Peter. Let me tell you what's gonna happen. Whenever you record a vesting deed, 90% of the time, there's gonna be a reassessment of the property taxes. And so many people forget this, and so many people don't talk about this. And after the close of escrow, there's all these reassessment tax bills, and the buyer's mad, and the seller's mad, and they come back and they want to accuse you, and then they come back and accuse title and escrow because they think we missed it, and we did. So let me tell you what happened. When you are working with senior citizens, or when you're working with a seller who has to record another deed before deeding to the third party new buyer in a transaction, that deed is going to trigger a reassessment. Okay, so in your particular case, we're recording 2 affidavits of death, and guess what? They have to have certified death certificates, and they reassess for the date of death, not from when you record it. So in the mother's case, 3 years reassessment. Okay, so you have to, as an agent, I know it's not our job, we're not the tax assessor's office, but it's your job to tell them, so to just inform them and advise them to talk to the tax assessor's office so that they don't get mad at you. So you're gonna have to tell Mr. and Mrs. Seller or their son, you know, in this transaction, we will have to record 2 affidavits of death. We will need 2 original death certificates. It'll all be done through escrow and through title as before we record the deed granting to the new buyer. Please save money, put aside, because there's gonna be 2 reassessments from the tax assessor, and it can come 6 months to a year after the close of escrow. This is true, okay? Especially depending on when you close escrow. So many times, this is what happens. So, mom dies 10 years ago, the family just records the deed. And I get it, as the public, you don't know that you're supposed to report a property owner to the tax assessor's office. I'm not sure if it's 90 days or 120 days. Now, tell me, I'm sorry, if I lost my mom, the last person I'm grieving, the last person I'm gonna go contact is the tax assessor's office. I get it. Nobody knows. If you're not in this line of business, you're not gonna know that you have to notify them. And you're supposed to record the affidavit death of a joint tenant, the affidavit death of a trustee. Nobody does that. I get it. And a lot of times they're done when the family decides to sell. But you can't avoid it. It can never be avoided. That's the tax assessors. Remember, what's the only thing that's sure in life is death and taxes, and that is 100% right. So it's when you record the affidavit, or the title company in escrow record the affidavit of death, then we do the new deed from the successor trustee to the new buyer. Well, the tax assessor doesn't know about this death. And the tax assessor won't know until the Hall of Records sends that deed down with the PCOR to the tax assessor's office. Then they have to process it. And depending on when this transaction, if it's around tax time, it could take almost up to a year, anywhere from 6 months to a year. So you have to tell the family members or heirs, especially if there's several beneficiaries. Oh my God, I have this many times. We're closing escrow. I advise that you're gonna get a reassessment from the tax assessor. I don't know how much. You can contact the local tax assessor's office, but I advise that the beneficiaries put some money aside. Keep some money in the trust, because that bill will come 6 months to a year, and you're gonna need money to pay it. Trust me, once the money's dispersed to the kids or to the beneficiaries, I guarantee you, it's gonna be hard to collect that money, especially if they spent it. Now, what happens in a case like this? Unsecured tax lien. That's a fun subject, unsecured tax lien. So what happens is, Peter buys the property and he gets a bill, a tax bill, reassessment. And on that reassessment tax bill, it'll say the deed that triggered that tax bill. Okay, and then in this particular, and it'll even say the date it was processed. So I get calls, and I know Alba gets calls, they get mad that Alba missed it or I missed it. No, it wasn't a bill, it wasn't a lien yet. You know, the tax assessor didn't even know about it. It was processed 6 months. Now Peter's the new owner. Now Peter gets this $4,000 tax bill. He's not happy. He calls his realtor and says, hey, what's this tax bill? I paid everything, prorated everything, so it'll soon to find out that it belongs to the estate of John Smith or Ann Smith. So guess what? All Peter has to do is take his proof, his grant deed, his closing papers down to the tax assessor's office, and they will take it off his property. So now it's no longer on Peter's property, and it's going to be on the estate and the heirs of the family of the deceased.
What about the bank? Didn't have any problem?
You'll be
No.
unsecured.
It's unsecured. That's why they call it unsecured, because it's there. So if they ever sell or refinance anything else, it's gonna come out.
Right.
Okay,
What
go
about
ahead.
if they don't own any real estate.
If
It's
that,
unsecure,
it's unsecured.
yeah, it
So they
doesn't
cannot
matter
collect it.
whether you own the property or not,
No,
you-
they
it's
will
on your
collect.
person.
Attached to the prop, attached to the
Trust
person.
Trust me, they find you one way or another, or the family, or the estate, or the heirs, or anything like that, you know.
They're going to look into that.
I wanted to mention also that if the property is sold under the living trust, the sellers must have an account under the living trust. Especially if they are, if the trustors are deceased, it has to go into the trust. Even if it is only one spouse alive. The reason is because you don't know, we are not to interpret the trust. So once it goes in the trust, the trustee becomes responsible for the disbursement of any funds. So, yes, Oscar.
Yeah, another thing I want to add is that, as Yolanda said, the assessment of the property takes effect when the trustee die. When you declare the effort in the affidavit of death of trustee, that is where they assess
Start assessing.
yeah, it really
The
says,
value.
the value of the debt.
From the-
Unless you have some parent to child exemption, which is by proposition 19, it's gonna get more complicated too. So.
And I have a flyer on that here, because I get
so
asked a
you
lot,
have
so.
to be very careful, you know, if you declare the affidavit of the trustee, and if they are qualified for the parent to child exemption, you have to declare at the time, otherwise the assessor's office doesn't know, so they'll automatically assess it without the parent to child exemption. And then when you want to redo it, reverse it, it takes a long time, but that's what happened to my mom's estate. You know, it took me 6 months to correct that mistake.
Yeah.
You know, so very, very careful.
Yolanda, question, if you don't mind, like,
We'll
our
get to your
friend
question.
mentioned it about the 3 years that the wife passed away.
Right.
She was married, so the property will pass to the living husband.
Correct.
They will still do the reassess to the property, even though the property passed
Well,
in the survival?
that is good, Alex, in the sense that we don't have to probate the wife. Okay, and it's right of survivorship if they're under a joint tenant or in a trust.
Correct.
So the fact that the wife passed first and the husband was still alive, that avoided probate. Okay,
Okay.
if it was under joint tenants or under a trust.
Okay.
But what it doesn't avoid is we still need to record an affidavit of death, and it's not the title and it's not escrow, it's the tax assessment.
And the assessor's office will reassess because you have to notify
You have to notify them,
when somebody passes.
yes.
Well, again, if you go and notifies the tax assessor, it hasn't to do a reassess because one survival is going to take over the property.
Well, as long as you do uninsured deeds, and we're gonna talk about that a little later, uninsured deeds, and you don't do things correctly, you can avoid it. But someday, they're gonna sell or refinance, and they're gonna have to do it correctly and have title insurance and escrow, and that's when we have to go clean all that mess up. And the longer we go back
Yeah.
and the more uninsured deeds and stuff is not taken care of, people die, it's harder and it's a mess, it's a mess. Go
Yes,
ahead,
Oscar.
Mm-hmm. So basically, it's about the same question, so if the property is in a living trust, and Mike passes away. 10 years later, but you know, but the kids are on the living trust, and they did not record that, they were supposed to record it, right? But
Correct, but I understand that they don't want, they don't.
so they're gonna, all of them are gonna get hit. They try to sell up.
Yes, the day it goes to sell a bona fide transaction, and it's gonna be done with title and escrow. Yes, those affidavits will have to be recorded. Now, I do have clients that sometimes they're taking a listing and the family already recorded the affidavit death of, already 2, 3, 4, or 5 years ago. So it's not like it's always the situation. I've seen the chain of title and I've seen, they've already recorded an affidavit 10 years ago. So the property was already assessed back then. So, no need to worry. This is if they didn't record any affidavits of death. And now we are ready to sell. And now we, escrow and we have to do that now to deliver clear title. Then that's when it's, now it's becoming,
So the keys decide to keep the property, they have to live, that's just the property, no, right?
yes, yeah, and
Yeah,
it
well,
will
yeah,
be, I mean, there's really no way of getting around it. I mean, there's just not, there's just not, you know, and so it's best to be addressed up front and when it comes to a lot of these things, and also what you were saying, because as more time goes on, people pass away, people move away, and it just makes it that much harder, you know, and so, yeah, it's difficult.
The new Prop 19 said, right, it says for the children to continue paying the parents' existing property tax. They have to live at the property, it's for a year since
No,
previously
yes,
or
a
after.
year ago.
It's
I think so, yeah, and I think it's in there, right,
a year before. After,
after.
oh, after.
That's what I understand.
Before the
And,
year
and you
is
know what I always do, and I'll tell you, my best friend, besides Alba, is the tax assessors in South El Monte. The one on Durfee, just south of the 50 freeway,
Get off of the.
they're my best friend. And I always go down there and ask them questions in person or call them. Because I'm not the tax assessor's office, I'm just giving or passing information. I'm only giving information of files and experiences that I have had with my customers. So that's why it's so important that you have your clients talk to the tax assessor's office, because you don't want that liability.
right.
You don't want that liability. I carry this everywhere I go. And you can pick this up at the tax assessor's office. And this is my little, oh my God, I just love it. And I always take a snapshot picture and send it to the agent and say, have your clients call directly. Because I don't want the liability on any of you. And I don't want the liability on me, because this is what they're supposed to do. But only the tax assessor's office can say yes or no to reassessing the property taxes or to a decline in value or whatever the situation is. So that's why it's so important. You don't have.
You know, you don't mind, like assessor office, the people are very nice to deal with. They are very,
Especially the South El Monte office,
everybody's afraid of, you know, because the government,
Yeah.
if you go over there, they are very nice to deal with.
Going to the downtown unless I absolutely have to. And one time I went with a client because of a reassessment and she was fighting it and she was literally fighting. So I had to go down there and I had to kick her like, be nice to them, be nice. And, you know, we need them on our side. She got it resolved and they undid it. You know, what she did was her her and her husband owned a couple of properties. And for whatever reason, I'm not a CPA, I'm not a tax attorney. Her CPA told her and her husband to transfer everything into the corporation. Oh, okay, don't ask me why, I don't know. And then a corporation had a completely different name, and then they reassessed the property taxes. And then she was fighting with them on the phone, so we went down there, I went with her, and then, because they don't know that corporation is them. They don't, you have to remember, you have to understand from the tax assessor's office.
Right.
How do they know it's them and not transferring it to a outside third-party corporation? So she had to go back with her articles, all her papers and all that, showing who's the chief of, you know, who's got signing power. It was her and her husband. Then they undid it. So I had to calm her down, had to kick her under the table and said, be nice, smile, tell her, get the guy, and let's get this thing done, you know, show them the paper, show them that it's you and your husband, it's your corporation, it's one and the same party. And so they undid everything and then lowered and they do it. Takes time. Don't expect it overnight.
That's why you have to do it right the first time. When you quit paying the property to the corporation, you have to do it correctly, and then you have to do the right preliminary change of ownership.
Oh,
Yeah.
from
that-
the,
and
to
then-
the corporation.
Yeah, from your person to the corporation. they have to do it correctly, otherwise there will be a session
Of course.
property.
You're right.
No, I'm so glad you brought it up before, hold on, I just wanna touch on that and probably Alba.
Camelia.
Oh,
Carly has
Cornelia,
a question.
oh my God,
Can you go
I
back to
can't
the-
tell you, people, I know you think that the PCOR is like, just like, it's like nothing. That is what's gonna save you from reassessing the property taxes or not, okay? It's so important that you read each line and check yes or no. And even on the bottom, I think it's like J or K or L, you know, it's blank. You know, I even specify even more. This is just a correction of name, even though it might have it, you know, like you make sure they know so that they don't reassess you. I know. There are some reasons why they won't reassess you, you know, husband and wife, or if you put it into your trust. If I'm like, my husband and I, and we invested our property into our trust, but it's our name trust, you know, so they didn't, you know, you make sure everything's filled out correctly and, you know, they didn't reassess it. But if you do things really different or kind of add somebody else's name, if you're like adding your mom or your sister and their name appears, now that could trigger a reassessment. So now you gotta go show your trust and show, well, I'm adding my sister, but it's also my husband and I. So, you know, you have to think from the tax assessor's point of view, they don't know you. They don't know your story. They don't know if this is your son or daughter, especially if they have a different last name. You know, but they don't know. And they're gonna be so fast to reassess.
If it's joint venture, then you can reassess them.
What do you mean as joint venture?
The same owner
It's
owns
one
it,
sentence.
and then they have somebody to do, let's say, develop the property or something, and they add somebody on it.
Yeah, you're adding somebody new, it's gonna reassess. Just a rule of thumb, I always tell people like. Whenever you record a vesting deed, it's like 90 to 95% chance it's gonna trigger a reassessment. There's very few exceptions, and you better fill out that PCOR, preliminary change of ownership, correctly. I'm sorry, did you wanna add something, Alba? Because you always work with the PCORs and the clients.
Even when you complete it and you submit it, they still send a new one to the client to fill out. So just
Okay.
redo it and send it back in.
Yeah, but just read each one and just really pay attention and take it serious because that's what could help, you know, if not, hold on, one moment, before we continue, before we go.
Two questions.
There you go.
That when a husband and wife have a trust, that if one of them dies and it, you know, and it goes to the other one, that it gets, the property gets reassessed?
No.
Yes, it did, when you record the affidavit of death of a trustee.
Yeah, you have to,
But-
your spouse.
Right.
You know, it's an unlimited, transfer from spouse to
Okay,
another.
so taxes are not,
It
well,
won't.
we just have to do the paperwork.
Okay, you have to pay the, do the paperwork and clearly indicated that there was happening money.
Okay, okay, and then my second question is more of a privacy question. It's really, I just feel like an invasion of privacy, but everybody has to see the death certificate and the reason for the cause of death. Is there any way that, I thought when you had a trust, you didn't have to show that to the public.
Okay,
You
No,
do
no,
because
the certificate of trust is not a public, information.
I see it.
It's-
only the affidavit of a death
Yes,
trustee
the
is public
certificate is there,
information.
but the death certificate. It was not shown.
Only if you file an affidavit death of trustee.
and a joint tenant, so it does get recorded and you can
You just
see.
blacked out, you just leave the 4 digits of the social security. Just black out the,
Sometimes I see
But the
that
cause of
people
death
are
will still be shown.
That's true.
not doing their
Yeah.
job.
but the cause of death will show.
So who's not doing their job by blanking out the information, like I see the social.
No, I agree, I freaked out. I did, because when you record an affidavit of death, unfortunately, the death certificate company. That's the only time, affidavit of death is the only time that the, death certificate is recorded. And you're right, you can see, I was shocked that the social security is on there. But the Hall of Records is the one that they don't want anything touched or altered. So it's not escrow. If escrow touches or alters it, they're gonna reject the document altogether. We can't touch it either. That's why they don't even want a copy, because they're afraid that we can alter, that's why they want the original or certified. And it just, what it is what it is. And I just have a hard time with that because I feel the same way you do. It's like, but I think the way, I know, especially with the crime and the way things are and all that, I guess the way they look at it, the mortuary and the Hall of Records, the way they look at it is, I guess once you're deceased, you know, your social security kind of, I guess, hopefully goes with you and nobody takes it and goes with it. But I feel the same way you do. I don't like that. Yeah.
Always asking for the original one, but who's the person that can't actually black out the social security number? Nobody can?
I don't think so. You can opt for
Well,
it. You can,
Even,
unfortunately.
even if you go directly to the office and show the paperwork and you tell them, I need to black out this number.
Well,
Maybe the Hall of Records.
Maybe the Hall, you see, the Hall of Records won't take it beforehand, so. I don't know, if you wanna be there at the Hall of Records when they record the transaction and then have a little blackout after they. It's the Hall of Records. It's the Hall of Records. I mean, it's not even us, but I totally feel the same way, you know, I'm like, it's personal information, that's the way I look at it. But going back to the trust, somebody brought up the trust and we were talking that when you're working on a listing and it's in the trust and you need to get that provided to escrow and then we need a copy of it. Let me let you know that we, if someone has cars, furniture, bank accounts, IRA accounts, planes, antiques, we don't want to know about that. We don't want to see that. If someone feels uncomfortable, we just need the main part of the trust, okay? So and we will work with people, so we will respect that, you know, with that information. You know, I've handled transactions with FBI agents, you know, sheriffs and police officers, they're very private. So, you know, we do take things into consideration and we're very private and careful. We don't sell our information, even the SI and stuff like that, you know. I handled a transaction for JFK's granddaughter. And you know, we did everything extra careful and private, and from what I understand, we handle the Kardashians. I don't, but one of my reps does. You know, everything is done very private, you know, so we do, but stuff that we can't hide. I mean, the Hall of Records is the Hall of Records. You know, but we do handle special where we, you know, and we don't sell our information and SI and stuff. Okay, I gotta tell this. Let me correct you before, I told you I was an agent real fast. Oh my God. So I'm all excited. I go, you know, oh, we have escrow instructions and SI, and I'm all excited to go sign with a husband and wife, you know, probably one of my first sales. And then I'm here having them to sign the SI. And it comes to previous marriages and kids, former marriages and kids. And the husband looks at me and then he waited a little later for the wife to walk out to the kitchen. I was married before and I have a kid.
And the wife didn't know?
You know.
The wife didn't know?
And the wife didn't know. And I'm like, to a separate form and I'm just like, you know, so seen and heard a lot.
Cancel the deal.
Okay, it's like to get it in there. Go ahead.
Yeah, there's never, but before that, I wanted to share with you that for those fast escrows, Anna, we see apart in the city of Los Angeles, certain cities, they have a report that needs to be done. Got pre-inspection, pre-sale. The city of LA, they have a 9A report. It takes 10 days. Okay, there's no other way. 10 days. They can go through the process. They don't go see the property, but you basically pay the $70.85 and you request it. So Anna and I were thinking, when you have your listing, let's try ordering the 9A report ahead of time. So at the last minute, in case there's anything, there's a sewers that are not connected, something you have time to address those issues.
Because delays on your escrow.
In those cases, because I went through very experience with that 9A report, an investor buy the property. They sign an addendum that says, I'm absorbing anything, I don't care, I just want to close the deal quickly. So with I can say escrow title companies, they don't have nothing to do with that.
It's a misdemeanor. In other words, even if you do it, it's not legal. You need to have a 9A report. So, yeah, you need to have it.
I'm sorry, Peter, you had a
Yeah,
question, I just had one.
But then some escrow will accept the certificate of the trust in lieu of the whole, comprehensive trust. So some of the information that, Yolanda was talking about can be kept, secret.
Yeah, as long as we
Yeah,
know,
but it has to be known, right?
right. As long as we know who the successor trustee is, who the beneficiary, we need to know, and is that property listed in the trust? Can they sell it? I mean, we need to know that part. We do not need to know the personal stuff about that.
So you don't know if the Kardashian, but everything they show is natural or is fake.
Okay, but going back to the F5, don't get in trouble, Alex. Don't get in trouble.
Come on.
Oh my gosh, this is gonna get me in trouble. Okay, going back to the SI, and I know Alba mentioned how important it is to get that up front. Please get that up front, especially lately we've been having fast escrow. And the SI, statement of information, or you'll hear it, we run a GI, general information index on a person. So, of course, what's recorded on the property is against the property. But what's recorded on one's name is recorded on any and all properties that they own. So what we will find when we run an SI on my name, if I have any federal or state tax lien, if I have child support, if, an alimony lien, if somebody's suing me and a judgment, someone took me to small claims court, all that's gonna show on my name. It's not gonna show when we run a property profile or initial prelim on the report on the house. Bless you. It's going to show on my name. And let me tell you, there are some names that are very common. And you have to be nice to escrow and to title, okay? Extra nice. So give us time to clear the name, okay? Like William Lopez, we gotta run Bill Lopez, Billy Lopez, but we have to run, and if it's a common name, so we need to know, and then that also gives you time to clear the property. If there is a federal state tax, that gives you time to work with your client, your seller, to clear and, clear that up, if it's not already, or child support lien. So this is just basically that old saying with the.
And the ugliest one is the lawsuit. If there's a lawsuit against the property. Yeah, because you gotta go back to the attorney, you gotta go, and they're still not in agreement, so.
What's that, Jerry Maguire, help me, help you, like, you give us the SI up front, order the prelim up front, because that way, you know what you're working with and have more time. One more thing I wanted to touch on, how much more time?
I wanted to see if anybody on Zoom
Okay.
has any questions. Any, I know, we forget about them. Anybody on Zoom have any questions for our speakers today? Going once?
No,
Oh,
Continue.
yes.
Some question?
no, I said no.
Okay, another thing I wanted to talk about, being that we were talking about trust and recording an affidavit of a trustee or like just say for an example, affidavit death of a joint tenant. Here's another one. How many of you work with investors? Okay, so let me tell you what's happening with that. Alex, I sell you my property, you buy it, you're gonna fix it up, and you're gonna turn around and sell it to Alba, right? So 2 months, okay, 2 months. And then you're gonna paint, carpet, and then sell it to Alba. So what happens is, we do title and escrow, you buy it legit, you turn around and paint it, carpet, fix it up, and in 2 months, you sold it to Alba. Guess what? You didn't give the tax assessors time to assess this grant deed here. Do you see what happens? So Alba is gonna get a tax bill,
Right.
a reassessment, a tax bill. But whose tax bill is it?
Mine, the investor.
The investor. So you gotta let them know. When you're working with investors and you're doing fast deeds recording, okay? Whether you're uninsured or insured, there's gonna be a reassessment and you're doing it so fast, you're not giving the tax assessors time to make it a legit bill, to make it, assess the file. So therefore, let the investor know, after the close of escrow, you're gonna put some money aside, you're gonna get a tax bill, could be 6 months to a year, but you will get a tax bill. Let them know, just like when you're working with seniors or a family of seniors, and you have to record extra deeds right before the close of escrow. Let them know. I had this one transaction. He is an agent, that's been in the business, he started in the 70s, so knowledgeable, broker, agent. And he took a listing in Temple City, and the lady had died. The owner never married, no children, and she died. Okay, the only heir was her sister in Oregon. Okay, so when they had to record the affidavit of death of a trustee, and then the sister was now the successor trustee, signed the deed to the investor. Okay, it was an investor, there was a fixer upper. Well, guess what? That supplemental bill came up. And who did that belong to? It belonged, because we recorded that affidavit of death of a trustee. So guess what? It belongs to the estate of Ann Smith, which, who is the heir? The sister. You know, that property was $1 million all cash. So, okay, she was mad. She was mad at her agent for not. Then that agent got mad at me for missing it. I said I didn't miss it. You know, so you know what I did? I picked him up in his office in Temple City. We drove down to the South Almani office. We took all the paperwork, and they said, no, this bill was assessed after the close of escrow based on the affidavit of death of a trustee, and it belongs to the estate of, so therefore it belonged to the sister in Oregon. So that's what I'm saying. I have no control. I'm not the tax assessor's office. And so that's why it's so important when you are working with families and we have to record documents like that. And if you have a question and you're not sure, call me. Even if it's not my file, call me. I look at it and I'll say, yeah, let them know that they might be getting an assessment and to keep money aside, you know, before spending it all. So again, it's so important, but that happens with investors too. And that was my key point. So when working with those people, let them know that they might get a bill 6 months to a year later to put money aside. That way, you know what? They're not mad at you. Because if they get mad at you, they may not refer you business or may not go back to you again. So you always want to make sure you give them the best information and that you were on top of things and that you look out after their best interest. And you were already ahead and telling them to save money. I'm sorry, I get carried away.
So how do you figure out how much money to get an idea?
I don't know exactly. And I mean, they have the formulas and you might want to call the tax assessor's office for that. And like I said, the Durfee South Almani office, the best. You could even walk in there. They're just the nicest people. And they can probably help you. I mean, I'm sure they have like a formula. Maybe it's based on what they bought the property for, what they sold it for. So, you know, that plus when that person passed away. So I'm sure there's a formula that the tax assessor has. I don't know what that is, and I can't answer that for you, but you might want to just contact the tax assessor. But I always just tell my clients to warn their clients, probably you're gonna get a tax bill. Save money. Don't be surprised, don't be shocked.
Another thing that we get to see a lot is the uninsured deeds. So whenever there's an uninsured deed, is because somebody transferred without title insurance. So the title companies are requiring an affidavit signed by the person who transferred out to make sure there's no fraud, duress, and that is right. And then plus, we will require a statement of information from that person. So right now I have a case. We have a lot of nightmare cases right now, but one of the ones that I'm really having now is that husband moved out. He transferred inter-household deed to the wife 4 years ago. So the title company now is asking for that husband to sign an affidavit. Well, he's willing to sign, but he wants half of the proceeds, even though he already signed off. So right now we're in the middle of an ugly divorce. Each of them have their own attorneys, and we'll find out what's. So that I got served with a change venue saying that I am to stop the sale or hold half of the proceeds. So at least I got the option to hold half of the proceeds. Because the wife hasn't made a mortgage payment for 7 months. So the best decision that we made right now to management, saying that allow it to go through and just hold half of the proceeds until they go to court and fight it out. So that's, so an insured deeds, make sure the family gets along. So because we're gonna need that affidavit, we're gonna need a statement of information, because anything that leans against that person who signed out, it will be, before the recording of the document, anything prior, if there's a judgment, lawsuits, tax liens, whatever, it will come out and we need to clear that with the transaction. So, and also another thing that we're noticing is power of sale. People don't pay their taxes for more than 5 years, it's gonna go to sale. So they need to find a way of paying that, so that way they won't sell a property with delinquent taxes.
I wanna go back to the uninsured deeds, that's such a huge topic. I can't tell you how many phone calls I get on uninsured deeds. So uninsured deed is exactly what Alba said. It's a deed that was done outside of title and escrow. Now, we see a lot. And here's the thing, the Hall of Records will record anything. They're not the title company, so they don't check the validity. They don't check to see if the legal description is correct. They don't check to see if the parcel parcel number is correct. They don't check to see is this person has the correct signing power and has the right to sell or transfer, or they're not a title company. They're just a Hall of Records. As long as the document is filled out, the notary is clear, the stamp is clear, and you give them the money, they're gonna record it, okay? I'm just being honest, I'm not trying to be mean, I'm trying to be honest, And so many of these deeds are not done correctly.
Right.
They're wrong, and wrong, okay? And so we have to clean it up, okay? And that file that she talked about, the uninsured deed, where the husband in the beginning of the divorce or separation, he was, I guess, wanted to get out so fast. He signed off quickly, and that's it, I don't want anything. He didn't give his wife any money mortgage, and he left her with a $25,000 debt. And the reason why I know that is because I have that transaction on the title company, and her wife called me. So I've had many conversations.
Personal loan, 25,000.
I don't know exactly if it's a personal loan or not, but she got
She
stuck with
says
it.
that she paid
So
$25,000.
she told me she paid it all off. Here's the thing, she was like, well, it's okay, just go ahead and close it, because she didn't wanna get, I said, no, we can't close it because he can come back and sue, and we have to deliver clear title and to the new buyer. We would not be doing our job for the new homeowner if we closed it knowing that your husband wants money. And my heart went, I had so much compassion for her, and I felt so bad, and I stayed on the up many times and a long time speaking to her. She told me really cute, and she told me, Yoli, she goes, but he signed and in front of a notary, so it's good. And I don't care, I'm sure that is his signature, I don't doubt it, I know he signed it. And I know he did it in front of a notary and it was legit. But the problem is that notary going to pay the $150,000 claim? Do you see where I'm going with this? I mean, we as a title company have to ensure clear title. The notary doesn't ensure clear title. They just notarize signature. And anyone can change their mind. And right now, one of the biggest claims for title companies is uninsured deeds. So you're gonna hear title companies more and more now. If you come up with a listing and there's uninsured deeds, we're gonna ask for what we call an affidavit of an uninsured deed signed by the parties, okay? And why is because the #1 claims that we're getting are uninsured deeds. We didn't ask for that affidavit of an uninsured deed. And then we close the transaction and then that person put the claim in. And this is how it works, okay? They were a partner, a business partner. They came off title and then they quit claimed, legit. That person's signature, notarized, legit. But then he or she finds out that the property is being sold. All of a sudden now, property's appreciated these last couple of years, right? Maybe they quit claimed off 4 years ago when the property was only worth this. And who knew that the property was gonna skyrocket? Guess what? They're coming back now and claiming they want money. And you know what they're saying? Oh, I'm a silent partner. I had bad credit and that's why I had to come off title. Or I had to do a loan someplace else and so I had to come off title, so I'm not on this property. Or, you know, so we hear all these stories. And you know what? We have to, you know, it's attorneys and time and money and we have to settle.
So would it have been a difference if they would have gone to an attorney and did it there? Would that have made any difference? If the
No.
attorney actually did the quick deed and got the notarized and everything?
Good question, Anna, and I'll tell you when it is good with the attorney. So in this particular case, unfortunately, they were going through the divorce, the one that Alba and I are working on. The only time that we will say, okay, 2 times that we say, okay, no affidavit of an uninsured deed. That person's deceased, obviously we can't get an affidavit of an uninsured deed from somebody who's deceased. We will ask for their death certificate. But the other situation, in a divorce situation, if the divorce was finalized and we would ask for a copy of the divorce decree, or at least the part that says who got the house. And if it is in the final divorce decree that the wife was awarded the property, then we do not need the ex-husband or to sign that affidavit, because you know what, we have a divorce decree saying that she's awarded the property. So that's the time. But honestly, I've had some attorneys, and with all due respect, there's a lot of good attorneys. But when it comes to title, sometimes they don't know the title issue situation. You know, they know maybe they specialize in their one thing, but you know, they're not insuring the transaction either. So sometimes they have a different mentality, and they don't have a title insurance mentality. All title companies have what we call underwriters and legal attorneys, just for title, for transferring title and protecting, you know, the clients and all that. So I do respect that, but sometimes we're not always on the same page and they have to understand, you know. But I've also seen some things done by attorneys that weren't done. I hate to say that. So, but no. So uninsured deeds, we have to go back to the last insured transaction. Sometimes it gets very messy. So a lot of times people are deceased. It takes a little while. You know, I always say every transaction is workable. I mean, if it has a pulse, you know, we can close it. You know, it's just a matter of, you know, going through the channels and getting all the right information and stuff.
And we have to work as a team.
You know,
That's
that exactly, you know, my thinking, and I know I was the same, is like, you know, every transaction is different. So we go plan A, then it's going plan B, and then plan C. I don't really take no for an answer.
We literally have to get it right.
There was probably 1 or 2 transactions I couldn't close, and then I'll tell you why we couldn't close them. Unfortunately, this was on the last crash, the real estate boom crash, when we had, what was it, 2010? 2008, 9, 10. And unfortunately, I had 2 files when they were doing those loan modification, okay? And unfortunately, people were like signing to people who, I don't even know if they were legit people or alive, people were alive. But on 2 files, 2 separate files, they didn't know who this person was. It was a common name and they were in Mexico, nowhere to be found. The sad thing is, I mean, there's nothing we can do. You know, that was bad. That was sad. And those went to foreclosure, you know, but there was nothing we could do. They didn't know who these people were. They couldn't come forward. They were common names with a ton of liens. We couldn't get their signature. We didn't know, you know, and that was an unfortunate situation. Yeah, you know, but any questions? I know I talk a lot and
You're doing great.
I know, but I just want you to know what's going on.
Why don't you guys do some?
Yeah, any questions? Any other questions?
Anything.
Anything?
We're here to answer all the questions.
I'm gonna go ahead and stop recording and I'm gonna end the meeting, but if you guys have
Thank you,
questions for them on a one-on-one basis, they'll be here for a little bit and stuff, okay? Thank you, everybody on Zoom for attending. I hope you guys got a lot of information that you can use. And we'll see you guys next Lunch and Learn, okay? Bye-bye.
Is there SI online?
Yes.